Good morning, everyone. Good morning. My name is Danielle McNichol, and I'm General Counsel and Director for the Center for Leadership. I want to thank everyone for coming today for the Pennsylvania Open Records. We have a very exciting lineup, so I really don't want to take too much of your time, but I do want to go over a couple housekeeping items for everyone. The restrooms are immediately outside of the doors here to the right-hand side. Emergency exits are in the back of the theater and the front of the theater. I always mention those for those of us who are emergency responders in the room. Today we are eligible for CLE, continuing legal education credits, CPE, HR, and social work credits. If you have not signed up, please sign up for the credits so that we're able to give you credit for those. For those of you who have CLE credits, make sure to give us the back page and put it on the table before you leave, signed. I'd really like to take a moment to thank all of the folks that have put this on today. I would have to say engaged citizens with Dave Woods. I'd like to thank the fantastic group of speakers that we have today, from the press to our legislative staff that has come in from Harrisburg, as well as our own local officials as well. It takes a lot of energy and time for folks to do this, and for them to take time out in the summer. We really appreciate it, and it is a fascinating topic once we really get into it today. The food sponsor today is Apple Walnut Cafe, so everyone please make sure to enjoy the food. Today we're going to have a break. After our second panel, we'll have about a 10-minute break. Please feel free to go out and grab as much food as you'd like. Use the restroom. It will be a brief 10-minute break so that we can get back and start our next panel, because we have a really packed agenda for today. So if everyone could do that, I would appreciate that. We are live streaming. This will be available on YouTube as well as on PCN, so feel free to go to our website. If you look on your open records, you'll see our website is on here, which is www.newmanpublicsafety.com, as well as our Neumann Leads Center for Leadership, 4.com, and this will be available as a training material or reference material for you moving forward. You can also watch it live here. We have open NU students is our open Wi-Fi for those folks that would need that. Any questions today, because we are live streaming, I would ask that you write your question on a white card. Pete Peterson and I will be passing around white cards throughout the presentations. So please make sure that you get a card from us, show us that you have a question, and we're happy to get that to the speaker. But simply because of the recording piece, we want to make sure that everyone understands that that's how we have to ask questions today. And then without much ado, I really don't need much introduction for the next panel here. We have of course, Phil Herron, who is our Executive Director for the Delaware County Times, as well. Excuse me, I'm sorry, I said the wrong paper there for you. And I apologize greatly for that. And Delaware County Daily Times. Sorry about that, Phil. We also have the Honorable Dominic Pileggi, and joining them shortly on stage will be Governor Ed Rendell. Gentlemen.
Thank you, Danielle. I appreciate the invitation to come and speak today about the open records law. And specifically, I was asked to cover the intent of the law and some of the background leading to its passage. I think it's necessary to start before the bill was introduced. The bill was introduced in early 2007, but the events that started in 2005, I believe, set the stage for the introduction of the bill in 2007. And most notable among those events was what was referred to as a pay raise vote in 2005, which started very active pushback against government actions, the way, not only the actions, but the way that some of the actions were taken. And there were electoral results with that pushback, which was, I think, the most notable aspect of it. And the first was the primary, or not the primary, but the non-retention of the court of a Supreme Court justice in, I think that was the 2006 general election. And the defeat in the primary of certainly two leaders in the Senate, the announcing of incumbents not running for election. So there was a real electoral effect to the pushback to that pay rate. In late 2006, I was elected the majority leader of the Senate Republican caucus, which was the majority caucus at the time. And the first bill, Senate Bill 1, introduced in the new session in 2007, was this, the bill that we're talking about today. It's also important to understand the context of that bill as part of a larger effort, I think, in reforming the way government was operating. There were a number of different pieces of legislation and rule changes in response to demands, frankly, from citizens for a change in the way we were doing business. So that was the background to the introduction of the bill in early 2007. The goal to the bill was pretty straightforward. It was to empower citizens to obtain government records more easily, certainly quicker, and with less cost and more certainty than was available under the existing law, which was first enacted the year I was born in 1957. How was that done? What are the key provisions that we thought would have that effect? The first was the change in the presumption. We created in the bill a presumption that government records were available to citizens, were open to the public. That was a major change in I think not only the practice of obtaining records, made it easier, but also it was intended, I think, has had a change in attitudes of government agencies. I think as someone who served in local government before being in the Senate, there was a sense that local governments had, certainly, and certainly at the state government level, that records were the property of the governmental agencies, and not so much expressed formally, but more in actions and how requests for information were dealt with. It's a very defensive approach, and sometimes in some smaller governments was expressed pretty bluntly that this is our business, not your business, and I think changing that presumption went a long way in changing that attitude. There was early on, and I think we tried to address it and did address it fairly effectively. There was concerns about how this presumption, this openness, would impact other statutory and common law provisions, and we were pretty clear that other specific state and federal laws would not be overrided by the Open Records Law. And certain common law privilege, some of them have been codified, some not, but things like attorney-client privilege, doctor-patient privilege, would not be impacted. Any other statutory exceptions, and there were some, we had a list of exceptions that I'm sure we'll be talking about later. And so the idea was that presumed open, but all of these well-established protections for records that would carve out areas where they were not available for good reasons that would be contained in each of those statutes or court decisions would not be impacted. The other thing that I think goes along with the presumption, but I haven't seen a lot of commentary on it, is the law establishes a floor, not a ceiling. Unfortunately, I don't think we've seen much of this, where there's a baseline where government agencies must make records available. That's the floor. But there is it doesn't create a ceiling. In other words, a government agency, although not required to release a record, may make a record available, subject to the constitutional limitations. We have this constitutional right of privacy now the Pennsylvania State Supreme Court has established. We have certain statutory protections that I've talked about before, but subject to those limitations. There's nothing that would prevent, certainly in the open records law, and I don't think anywhere else, a government agency from going beyond what's required by this statute. The other, I think, areas worth noting in the passage of the law, trying to make this process easier for citizens, was enlarging the scope of the law. We included the General Assembly. We did treat each branch of government differently, the judicial, the legislative, and the executive branch, as most laws in other states do. And we included the state-related institutions, Penn State, Pitt, et cetera, Temple, in the law. They were not part of the previous law. They're not purely state agencies. They're treated differently, but they were included in the framework of the law. And we included third-party entities that perform government functions. It's an area that the courts have worked on a little bit since then, and it's a complicated area, but it was included intentionally. With the reality is that there are a lot of private entities, non-governmental entities that are performing governmental functions. The second major thrust beyond presumption was the creation of the Office of Open Records. And we're privileged here somewhere, where is she, to have the first director, Terry Muchler, here, and the current director, Erik Arneson, here from that office. So I'm talking about the intent. They're going to talk about the operation later, but the intent was pretty clear, and it goes back to the original goal. It was to create some uniformity in Pennsylvania. If you remember, before this act was passed, the patchwork of court decisions, every local agency had their own policies for mundane things like how you request records and how much it costs for you to have records reproduced, how much time. These sorts of things varied greatly. And the intent with both the statutory provisions and the creation of this office was to standardize things across the state. So there'd be a central clearinghouse, if you will, repository, point of contact that would help to increase the uniformity of how people access records. I think it's been largely successful. That was the intent. The other was to reduce cost. It's certainly hard to argue that an appeal to a court of common pleas is a more expensive proposition than an appeal to an administrative office like the Office of Open Records. So a citizen who's contemplating a request, knowing that if they're unsuccessful, their next stop is an expensive stop at the courthouse rather than an administrative process, it acts as a deterrent effect, I think, and that we thought at the time. And having a less expensive, quicker resolution of that dispute through the Office of Open Records was in line with the goal of the Act. The other, and I think this gets lost sometimes, the other intended goal of the Office of Open Records was to have it serve as an educational law, and I think it has done that well to educate not only government agencies but citizens on how the law works and how it should operate in practice, and that's a role that I think the office has taken on, but has sometimes been forgotten as part of the intention of the Act to make it easier for citizens. The expectation at the time was that we knew this was a large piece of legislation, and a a lot of moving parts. It took about a year from introduction to passage, and I see the governor's joining us. Governor Rendell, I'm almost finishing up. But it took about a year from introduction to passage, a little bit more. And anyone who looks at the bill history will see that it went back and forth at least twice between the House and the Senate. And it went through, for those of you like this sort of thing, 10 separate printer's numbers. So if you want to follow legislative history and try and track those 10 numbers, that's not something I'm intending to do in my 10 minutes, which are just about up tonight or today, but there was a lot of back and forth, which reflected a lot of work over that year and working with the various interest groups, from the ACLU to the District Attorneys Association and Newspapers Association, all the various interest groups that had an interest in this legislation. The other thing about setting at the time, we had a majority in the Senate, we being the Republicans, and the Democrats had a majority in the House, so they controlled the agenda there. And the governor was Governor Rendell, and so it was truly, it had to be, and it was a bipartisan effort. It wasn't a Republican bill, it wasn't a Democratic bill, it was a bipartisan bill, and would not have been successful without compromise on both sides. And if you look at the votes on final passage, I think they were unanimous in the Senate, and if not unanimous, near unanimous in the House. So it ended up being a bill that had broad support. I do want to mention a couple people by name. At the time, my policy and communications director was Erik Arneson, and Erik was very instrumental, not only in the formation of the bill and the idea of advancing this issue, but also in the negotiations and the passage of the bill. And I haven't seen her here, but my legislative attorney at the time, Kathy Aiken, those 10 back and forths that I talked about, Kathy Aiken, I think to this day, is one of the finest legislative drafting attorneys that ever served in the General Assembly, and she managed that process. And the legislation has been examined front ways, sideways, all sorts of ways through various court decisions and challenges. And I think it's held up well. I mean, anything can be improved, especially legislation. We had, before I left the Senate, introduced a comprehensive bill that I think covered a lot of those things that we learned in practice after the bill had been used for a while, and some of the issues that people brought up, and unfortunately that bill did not get to the governor's desk, and to this day I don't think it's moved. It moved through the Senate but did not move in the House, but that's for another day. I also thank Governor Rendell. Would not have been possible without him. He was very supportive of the process, signed the bill, and beyond that, I think set a very strong signal when he appointed the first director, Terry Muchler, who had the difficult task of setting up this new government agency, a very unique agency in the way it was constructed. And Governor Rendell found a very skilled, independent person to do that, and I think showed the level of his support. It wasn't just, I'm signing the bill, it's I'm signing the bill and I'm committed to getting this process underway. So I think with that, my time is up. I want to thank you for the opportunity to speak to you. Look forward to the program today. Thank you.
And at this time, we would like to welcome comments from Governor Rendell concerning the creation of the first Open Records Office. Governor Rendell.
Good morning, everyone. Sorry I was late, but I just wanted to make Senator Pileggi feel at home. I was always late when I was governor. So, the Open Records Act was more a legislative creature, although, as Dominic said, the administration did have some input into it. But I want to compliment, I still call him senator, not judge, but I want to compliment Senator Pileggi and his staff. They did a very good job. You know, on the one hand, it seems like it's self-evident. Well, yeah, open records. Everything the government does should be open. Everyone, show of hands if you believe that everything the government does should be open to the public. You're wrong. You're wrong. I'll give you a perfect example. My predecessor was Governor Mark Schweiker, good man. And he had to deal with the immediacy of the post-9/11 world. And we deployed National Guard troops to protect our 5 nuclear plants in Pennsylvania. This was right after the 9/11, and what would have been more of a ready target in Pennsylvania than the nuclear plants. If you really wanted to cause trouble, you could have a Chernobyl-type incident. The nuclear companies will tell you, no, it's impossible. But you could have had a Chernobyl-type incident if sophisticated terrorists decided to go after a nuclear plant. So Governor Schweiker very appropriately announced that he was stationing National Guard troops. But he didn't announce that they weren't given live bullets. Now, if you were terrorists, would that have made a difference to you? Do you think the public had a right to know that the National Guard didn't have live bullets protecting nuclear plants? And there was a good reason that Governor Schweiker decided not to give the Guard real bullets. But obviously, that's not a good thing for the public to know. So start with the proposition that there are some things, extremely limited, but there are some things that the public shouldn't have the right to know because it's deleterious to their own interest. During negotiations, the negotiations, for example, the administration had with the unions, you don't want to force both sides to negotiate in public because we have our constituencies, elected officials, obviously, the citizens, and the union leaders have their constituencies, the union members who have to vote for their election or re-election. And there are some things in the run-up to making a deal. There's some posturing going on. And if the union made, the initial demand of the union was for a 7% raise across the board for 3 years, 7, 7, and 7. That might get hard. It might make it hard for them to settle for no raise in the first year, 3% in the second year, and 4% in the third year. So again, start with the proposition that there are some things, very limited, that the public shouldn't know about. But most things in government, the public should know about. And government works best when there is as close to complete transparency as possible, because transparency makes sure that people don't screw around, that everything is reported, that the citizens can see how money is being spent. For example, something that was recently in the headlines, spending money to settle against elected officials or appointed officials to settle cases involving sexual harassment. Should the public have the right to have known that that was going on, that taxpayers' dollars were being used to settle those suits? Sure they should, right? It's your money. You have every right to know how your money is being spent. No question about it. I guess the hot issue, I don't know if Erik is here, but the hot issue right now is, does the public have the right to know? And of course, that means the media, the press, what's in the offer that the state made to Amazon. The position of the administration, and it's tenable, is that if the public knew right now, it might make it more difficult if Amazon comes back and says, all right, Pittsburgh, you're in the final 5, but we want to change A, B, and C in your package. again, it's hard to negotiate anything in public. But that's a pretty important thing. And the only solace is you're going to know afterwards. And you're going to know afterwards, and then you, the public, can judge whether it was a good deal if we got Amazon. Did we give away too much? Are there guarantees that we're going to get the jobs they promised? What happens if they don't produce 50,000 jobs? Is there a clawback? Those are things the public has a right to know. The bill is basically a good one and a sound one. Like all bills, it can be improved, and I think has been improved, Dominic, since the original passage. There have been amendments? No? Has the bill been successful? No, not yet, but I'm sure that someone will take a comprehensive look at it. The most important thing I did was appoint Terry Mutchler. And Terry Mutchler did a good job, and she's well qualified and experienced to do the job, and she did a good job. But the most important thing about Terry Mutchler is I didn't know her. I never met her. I didn't know whether she was a Republican or a Democrat. Turns out she registered independent. I'd never spoken a word to her until they brought her into my office for an interview. I had to sign off on the hiring of her. But it was important for me to find someone that had no political affiliation with any Pennsylvania elected official and who had a tremendous degree of independence. Because I knew that there were going to be times that there might be things that the Open Records Commission would be asked to release that I might not want released. But if I had someone who was beholden to me, or even had the appearance of being beholden to me, it would cut the public's confidence in the act. When Terry Mutchler was leaving, or forced to leave, or whatever the facts were, I wasn't in Harrisburg at the time. Tom Corbett was governor. Governor Corbett appointed Erik Arneson. Erik is a terrific lawyer, probably as knowledgeable about state government as anybody alive when I was governor, and probably still today. And someone whose integrity I don't question for an iota. But he was a bad choice, in my judgment. Not that he's done a bad job, he's done a good job. Not that he wasn't qualified to do the job I just said, he knew state government better than anybody. But he was counsel to the Republican Senate caucus for years. In that role was a strong partisan. I know he was a strong partisan because I couldn't read a newspaper every day without Erik Arneson ripping me. So I thought he was a horrible choice. Now, there are two things that make a choice. Is the person substantively going to do a good job? And by all accounts, Erik's done not only a good job, but he's done a great job. But how does it look to the public? How does it look to the public? If Erik Arneson then had an issue that the Senate Republicans, or the Senate and the Republicans had the majority, didn't want some records released, and Erik Arneson had to make the decision. Even if the law should have been decided that they should not be released, even though that may have been the right call on the law, does that inspire citizen confidence? I think it was a problem. I stayed out of it. I didn't opine about anything, but I thought it was a mistake. I thought it was a mistake for Erik too, because it's a no-win job. Terry Mutchler left Harrisburg as one of the most hated people in the city. But that's how you know she was doing a good job, because we hated her. I appointed her and we hated her. But that's how you know she was doing a good job. Both sides hated her. And with that, I'll stop, because I think we will benefit most by question and answer. But Erik's not allowed to ask a question.
Oh, good morning. My name's Phil Herron. I'm the editor of the Daily Times here in Delaware County, and it's my honor to serve as the moderator for the question and answer session. My thanks to first Senator, now Judge Dominic Pileggi from right here in Delaware County, and of course former Mayor and Governor Ed Rendell. Also, I want to thank the Center for Leadership here at Neumann for offering this opportunity. Judge, I will have to tell you that I was struck by something that you mentioned in your opening remarks about the law and this idea of presumption. The presumption that citizens have a right to know. Well, doing what I do for a living, I will turn that around and tell you there's another way to look at that presumption, and that for 51 years in Pennsylvania, the presumption was that you had no right to know what your government was doing, what those documents entailed. The presumption was that that was a secret, and it was incumbent upon you, the citizens, to prove why you thought you had a right to know that information. What the law did, literally, was take that equation and stand it on its head, and rightly so. So I congratulate then Senator for his efforts. I couldn't help but notice, in going back and reviewing some of the things that we did at the time on the law, that Governor Rendell put his pen to paper on that law on February 14th of 2008. I'm thinking that was probably a Valentine to the newspaper industry and others in the media at that time. I will start the questions, and as we said, you had cards that were given out to people, so if you have questions, you can get those to the edges and bring them up, and I'll put them to both the Judge Pileggi and Governor Rendell. Judge, I thought it was interesting that you mentioned the political atmosphere at the time, which sort of was the initial cauldron for some of this. And one of the things that I would like to point out, something that doesn't happen very often, especially today, is that you would take note that this is a legislative initiative sponsored by a Republican senator, head of the Senate Republican caucus, and signed into law by a Democratic governor. Not something that happens every day here in Pennsylvania. But Judge, for you, if it had not been for the pay raise and the huge backlash from the public and the clear evidence in the subsequent primaries that there was going to be a price to pay for that, would you have been able to get the law enacted without that kind of backlash?
Hard to say. Possibly. That certainly was the mood of the citizenry and the election results. I think forced legislators to pay attention to reform efforts like that bill. It wasn't, even with that though, an easy sale. As I said, each group had, and whether it's the boroughs and townships or the League of Cities or the District Attorneys Association, each group had their own particular concerns that needed to be addressed and ironed out. And in the end, I think every major interest group that had any tangential or direct interest in the bill was for the bill. I don't think we had any straggle. We might have had a straggler or two, but by and large, and there was support. So, and the fact that it was bipartisan in nature, I can't say it wouldn't have happened. It would have been more difficult because the urgency of the next election coming up wasn't there for legislators to think about.
Mm-hmm. I think it would have passed eventually, maybe not as quickly, but we were fortunate to have Senator Pileggi in leadership. I don't think it happens with anybody else in leadership at that time. So I think that was a key factor. Also, I want to echo what you just said. Neumann should be congratulated for having this very long examination of an important public bill. We ought to do more of this. We ought to do, in a nonpartisan setting, we ought to take a look at a piece of legislation. Has it worked? Does it need changing? And it shouldn't be a 30-minute or 40-minute speech by even someone knowledgeable. It should be this type of thorough examination. So congratulations to him.
One thing to keep in mind, we keep referencing state government because of the fact that it was obviously legislation that worked its way through the legislature, both the Senate and the House pushed by then Senator Pileggi. But keep in mind that this is not just something that happens at the state level. This is a huge trickle-down effect. This is something that happens in every one of your towns, in your township, in your borough, in your county government, in your school district. I can't tell you, every day I take phone calls asking what they're going to do about reining in costs in the school district and trying to get rid of property taxes. And eventually, every time that comes up, people want to know who makes how much. Well, one of the ways we find out that, when your school district hires a new superintendent, this is how we find out this. If the school board is a little reticent, amazingly, when they put out their press releases, they don't always list the salaries that some of these people are going to make. We ask, and if they seem to be reluctant, then we remind them that this is the law now.
You just reminded me of something. This is probably not exactly on point, but when I was mayor, there were groups that conduct tours for school kids at City Hall, usually elementary school kids. And I would tell them, check and see if I'm available in the office. I'd like to talk to the kids for 10 minutes. I did it 2 or 3 times a week. And I would ask the kids if they had any question. Invariably, first question they asked was, how much do you make? And I said at the time, $110,000.
Future reporters.
Right.
First question you always ask.
And I said at the time, $110,000. They went, ooh. I said, wait a second, guys. Anybody know how much Michael Jordan makes in a year? They didn't. I said, $70 million. I said, I would have to have been mayor for 680 years to make what Michael Jordan made in 1 year.
That's a good answer.
It's right to know.
I can tell you that in the years longer than I want to admit that I've been doing this, there are very, very few things that we have done that got the reaction of one publication that we did. And I don't know what was the emphasis behind it, but we decided that we were going to run a special section. And in that special section, we were going to list by name the salary of every public school employee in Delaware County. And that went over and was like electric. And I can't tell you how many phone calls that I got saying, you know, after they got done screaming at me for 15 minutes, they asked, well, when are you going to publish your salary? And my response always was exactly along these same lines. As soon as the public starts paying my salary, then I will do that. These are public documents, things that are of the public knowledge.
But remember, if a company is public,
yes,
it's a public company, even though it's not a government agency, they've got the requirement of publishing salaries as well.
I guess that's as opposed to one that's held privately by a hedge fund.
No, that's right.
Governor Rendell, talk a little bit about this idea of bipartisan action, which happened then, and why we see so very little of it now.
Well, of course, the tenor of the times has changed, and it gets worse every year. I was very fortunate that I had strong leadership in Senator Pileggi and Speaker Purcell when I became governor that had an interest in making government work. They were conservatives, but they were ideologically conservatives, but they knew that government had a role in our lives. Regardless of what part of the political spectrum you're from, government has to do something. You know, even the most conservative people want government when a hurricane hits their town. They want government if a riot breaks out. They want government in a snowstorm. Government has to work. The Republican leadership at that time understood that. The Republican caucus, who elects the leadership, grudgingly understood that. But there was strong leadership to try to make them understand that. And you could negotiate with them. Probably the bill that I did that had the most long-lasting effect was an economic stimulus package before President Obama created his economic stimulus package and gave it sort of a bad name. He didn't give it a bad name, but his critics did. Our economic stimulus package worked tremendously. We were 46 in job creation the day I took over as governor. The day I left, we were 9th in job creation, the highest of any industrial state in the country, because of the economic stimulus bill. We worked on that together, And the Republicans had made some very good substantive suggestions that we actually put in the bill. And they made one suggestion that I didn't like. They wanted the money under the stimulus to be distributed by a control board, not by the governor. I wanted it distributed by the governor. I believe that I would distribute it in a fair way, that I wouldn't be partisan in doing it, and that I could do it more quickly. But they insisted on doing that, and I had doubts, particularly because they said all five, the governor and the four caucuses, all had a voting member of the board, and they all had to agree for every grant. Well, that gave them veto power. If you don't do the grant that I like, we're going to vote no on all of yours. But fortunately, everyone who was appointed took the job seriously, and it worked. And it was a small price for me to pay because it was about $2.5 billion of government funding, loan guarantees, things like that. Produced $19 billion of private sector money. It leveraged $19 billion of private sector money. Pennsylvania put $21 billion into its economy in the next 3 years. So leadership was different. The tenor of the times was different. It was easier. But eventually, the word has got to get to everybody that government has to do something.
Some questions that were submitted by the public. There's a person after my own heart. Oh, my goodness. One of the things that was mentioned, both by the judge and the Governor Rendell, is that the law has not, in fact, been amended in the last 10 years since it was enacted. Well, in those 10 years, things have changed just a bit.
And then some.
Question: in this day of social media and cell phones, are text messages, etc., social media posts sent on government phones and computers subject to open records and available to the public?
You wrote it, Dominic.
No, it's the idea that is behind the legislation. I think the court interpretations follow this, unless I've missed one, is it really doesn't matter what the medium is. It can be ink on paper, it can be a formal letter, it can be a text, it can be an email, it can be a whiteboard, a PowerPoint presentation. It can be on any medium. So whatever the new ones now, Instagram, or if someone, whatever the medium is that the government employee uses, it doesn't change the fact that it's a record. So
yeah, I think the only issue, and you probably should ask that question, Eric, but I think that's correct. The only issue is does a public official not come under the act if, like, for example, if he pays personally, if he pays for his own cell phone, his calls on his cell phone that is not paid for by taxpayers' dollars, is that covered? Eric, what's the kind of interpretation on that?
If it's documenting a transaction or activity of the agency, if you do it on Gmail or your personal phone or whatever, if it is something official to the agency, it's still a record. Harder to get to.
Right. But it would have to be as some official task.
Another good question, because again, we tend to think of this on a statewide level, and we all like to take our shots at the state and state government and bigger entities, bigger agencies or whatever. There's also a flip side to that as well, and that is there any consideration given, or is there consideration given in the legislation to sort of ease the burden on smaller entities, smaller agencies, smaller local governments?
This was something we talked about at great length and made some changes in the legislation along the way to try and address that concern. We don't have any of them in Delaware County, but there's some rural local governments where just there might even be some in the dozens of citizens, but certainly many with just a few hundred citizens and part-time employees, no township manager, no So that was something we were cognizant of, and the bill tried to address that, and I think did. But I think even the smallest municipalities now, have internet access and photocopy machine and that sort of thing as technology becomes less expensive. And frankly, the new technologies made the legislation easier, I think, to implement and less costly. Things are all digitized now, which reduce costs, which, if you go in the days before photocopy machines were commonplace, and trying to do the same thing would be difficult. I think one of the things, and I might be wrong on this, was there was a discussion about requiring certain things to be put on a website as a way to reduce cost. And I think the pushback, if I recall correctly, 10 years ago, and that's quite a leap, was that some municipalities, some of the smaller municipalities, not only didn't have a website, they didn't have a computer. And so we didn't go in that direction. But it's something that was considered, tried to address it, and
But
as I said,
as a substitute for classified advertising, obviously.
that's a different issue. That's a different issue.
Another question, which sort of touched on, so I'll sort of morph it into the next area, a question about pending amendments. We obviously indicated the Senator said that there have been no amendments to it. So I will ask you, Judge, in looking at it now, what should be done to increase the bill?
Well, for a comprehensive answer, take a look at what was Senate Bill 411. I don't know if it's retained a number or if, who's picked it up to run with it, but there are a number of issues contained in that bill that, at least at that time, were the issues that I thought needed to be addressed to improve the operation of the bill. The major areas of I'll say unexpected areas, the issue of commercial requesters. Our focus, as I said in my remarks, was on citizens and empowering citizens, making it easier for citizens. This being a capitalist society, people who are in business for profit quickly became aware of the potential to use the act in the furtherance of their business interests, and that's okay. But many of those requests have become burdensome, especially to smaller governments, and so that was an issue that we've addressed as best as we could in that amendment. The other unexpected thing, and I'll just hit a couple of them, was the volume of prisoner requests. We didn't expect that, and the bill's amendment had provisions had provisions for that. And then the other, frankly, was, given all of the various court decisions, the process and procedure by which the Office of Open Records operated, and the timelines were adjusted in the amendment. And then there are three basic areas, with a number of smaller issues that I think are very easy, non-controversial from my viewpoint, but for some reason the House has decided that they don't want to take those up.
Kind of an interesting aspect of it that we didn't touch on as yet, and that is tried and true, going back to the saying that nothing in life is free. Well, a request under the state's right to know law often also is not free. And a person in the audience, my guess is maybe a local official or school board member, wants to know why those requesting the information are not required to pay all the costs associated in responding to those requests.
Well, the Act sets up a fee, sort of a standard fee, and as I recall it, somebody will correct me if I'm wrong, for extraordinary requests, if the agency can prove a cost, there's an ability to be reimbursed that cost. But they're out of the ordinary request, and that's the way I remember it. And The other thing that I'll mention is, so let's just say some agencies are better than others at the way they manage their records. And if your records are well managed, the burden for that agency to reply to a request for information is much less than an agency that doesn't manage their records well. And should the requester pay more for records from the poorly managed agency than for the well-managed agency? So there are issues, the cost issues I think were addressed in the amendment, and I might be conflating the amendment with the original bill, but the cost issues have been raised, and the extraordinary cost issues, and I'll defer to someone who's more up to date on where that amendment is and how it addresses it in that bill. I don't know what the current state of that is.
Kind of an interesting corollary along the same vein. Why doesn't the bill, I would guess that this would probably pertain mostly to at our local level, why doesn't the bill restrict requests to the requester's municipality? So I would assume that would mean that if you're requesting something from the school district, that you live in that school district, or if you're requesting something from your borough council, that you be a resident of that council or that municipality.
I don't know. We live in a commonwealth. I mean, that would be my answer, and every citizen of the commonwealth should have an equal right to obtain government records. But someone might have a different view. We did have a debate, I think, I know we had a debate on Pennsylvania resident versus U.S. citizen, and even citizen versus non-citizen. That issue came up and was batted around a little bit, but I don't even recall someone saying that you have to live in, or in Aston Township. You have to live in Aston Township in order to find out. You can be a taxpayer in Aston Township and not live here, for example. You can work here and not be impacted by the Aston Township government, not live here. So I don't even think that came up in the legislation, at least I don't recall.
And remember, the act does limit fishing expeditions. So a citizen can't come in and say, I want every document that's been published by the government, every bill of sale and bill of lading over the last 4 years. It's got to be narrowed to a specific purpose.
An interesting angle, Senator, for you. Again, when you were considering and drawing up the legislation for the state's right to know law, did you look at other states? Did other states have laws in place? And did you base and work off of those in drawing up the Pennsylvania law?
We certainly looked at other states, looked at the federal.
Where was Pennsylvania in terms of, where would you rank them in terms of open laws situations across the nation?
I'm looking at Terry Muchler. We went through these rankings. I think it was ranked in the bottom 10, if I recall correctly, as far as 49 and 50. Afterwards, I think we jumped up a number of, certainly in the top quarter, if not the top 10 states. By different people rank that differently, so it depends on how you look at it. But for example, I recall we based the treatment of the General Assembly on the New York statute, which had gotten high marks at the time compared to other states, and how open records laws in other states treated the legislative body. So we did look at others, but it's not modeled on one particular state.
A final question to wrap up the session, and I think a good way to wind it up. And I'll ask both the judge and the governor to respond. Now that the law has been in place for a decade, any examples of things that you hadn't thought of or unintended consequences to the fact that the law has been in effect, and maybe something that should be targeted in an upcoming amendment? Governor?
Again, I haven't followed this probably as much as I should have, but no large area, no crime need comes to mind. And at least during the first 2 years that I was governor, Terry would not have hesitated to bring ideas for legislative changes to us, and she may have, but I don't remember.
Senator?
I think I mentioned the two that strike me the most, or the most clearly, the commercial requesters, people trying to make a profit using the law, and should they be paying the same fee as a citizen, and how do you identify those people in the first place? Because generally the law does not require or doesn't go into requester's intent. So that's one issue. And the other is how to deal with inmate requests, which create a lot of workflow and tend to be problematic, especially for the Department of Corrections, but then beyond that for other agencies. So how to deal with that while still respecting the rights of inmates while they're incarcerated. So they're the two areas that I think most clearly could benefit from some legislative action.
At this time, I'd like to thank Phil Herron, Governor Rendell, and Judge Pileggi for your time here today, but also for understanding the importance of this law to the Commonwealth and continuing to keep the dialogue going on this. Thank you, folks.
I love the letter to the president. I don't think he'll respond. I just thought,
He responds to everything else. I don't know why.
yeah.
Yep. At this time, we'd like to talk about the Pennsylvania Open Records Law from the media's perspective. John Baer, the political columnist for the Philadelphia Daily News, will be our moderator. Panelists will include Phil Herron, as well as Joe Conti, president of the Pennsylvania Association for Broadcasters, Melissa Maluski, legal counsel for the Pennsylvania Newspaper Association, and Kristen Johansson, reporter from KYW News Radio. Come on up, folks.
Okay. Good morning, everybody. I'm John Baer from the Philadelphia Daily News, the Philadelphia Inquirer, Philly.com, soon to be rebranded as something so we won't have 3 or 4 names. There isn't anybody that likes open records more than the media. Trust me. I mean, if we could do one thing to the law, it would be we don't have to file anything. We just have to ask, and you have to tell us. So that would be my primary change in the law. We have the whole panoply of media with us for this great panel, and thanks to the Center for Leadership at Neumann for inviting us. Usually nobody cares what the media thinks, but you're going to get a dose of it, I think, today. From print, we have Phil Herron, longtime editor of the Delaware County Daily Times. From radio, we have Kristen Johansson from KYW News Radio. We have the much-traveled and former state legislator Joe Conti, who is currently president of the Pennsylvania Broadcasters Association, and Melissa Maluski, who is legal counsel to the Pennsylvania News Media Association. I'd just say that among the hot topics that are kind of out there right now, and if you talk to the Office of Open Records, I talked to Erik Arneson yesterday, called him and said, listen, I have to moderate this gig on the right to know law, and so I thought it might be right for me to know something. And so we chatted a little bit, and he assures me that the law is working well, that most agencies are not having a problem, that the fiscal impact, which was discussed briefly, is not great on the agencies, and that everything's going swimmingly. I think we might hear a little bit of contention about that. There is some stuff out there that we might want to talk about. One is the You might recall the Stack report, when Lieutenant Governor Mike Stack got into some trouble with his boss. There was an IG, an Inspector General's investigation. The governor indicated that he might well release that report. That has never been released. Believe me, we have tried, and it is under the exemption of non-criminal investigative stuff that the Inspector General's office holds, which is a shame in my view. But, and the Amazon stuff that you heard a reference to, the proposals, of course, everybody has filed for those, and the Office of Open Records correctly said yes, they should be made public. So that goes to the appellate courts, and no doubt will not be settled until Amazon actually awards its thing, so that'll be hidden from the public as well. You can expect in an election year an uptick in filings because everybody doing opposition research on every candidate will want to know everything they can about the other thing, about the other candidate. And finally, before we get started, the thing that surprised both myself and Erik Arneson is that the most contentious battle in Harrisburg and in the legislature right now over the issuing of gerrymandering and how the state Supreme Court used unusual authority to draw its own maps, despite the fact that the legislature has the authority to do that, did not produce right-to-know requests for communications between the governor, Democratic leaders, and the court, which makes me think maybe I should be filing one soon. So why don't we start with, we've heard all the good things about it. Melissa, I suspect, has a couple of complaints from representing the media from the legal aspect. Melissa, go ahead.
Well, I won't say they're complaints, but folks don't call me to say things are working well. Folks call me when there's something going wrong. So in my position with PNA, I get about 2,000 calls a year, calls and emails. Most of those have to deal with public access issues in Pennsylvania. That number has remained consistent. I was in this position before the new right-to-know law took effect 10 years ago. It's been about 2,000 calls a year for the past 12 years. So I think the questions today that are asked are different than the ones that were asked before the law went into effect. But I do have to say, and I say with great confidence, that Pennsylvanians are better off today by leaps and bounds than they were under the old, more restrictive right-to-know law. You know, we are far ahead of where we were 10 years ago. But there are still issues with Pennsylvania's law that can be improved, and some places where access is actually worse today than it was 10 years ago. And so those are the places we'd like to see improvement. Most of those have to deal with the investigation exemptions in Pennsylvania's law. There are both criminal and non-criminal investigation exemptions in the law that are very broad and have been very broadly interpreted by the courts. So we'd like to see those narrowed because they have the potential to swallow the general presumption of access if they're applied improperly and too broadly. Under the old, more restrictive right-to-know law, reporters routinely got access to criminal incident reports from both local and state police. We no longer get those under Pennsylvania's right-to-know law today, and I think that is to the detriment of not only the public, but the law enforcement officers and agencies who are serving the public. When there's secrecy, it creates the appearance of impropriety, even when everything is going well. So that the fact that we have this significant barrier to access under current law, we believe needs to be addressed. With regard to the non-criminal investigation exception, under the 1957 version of the law, we got access to the final results of an agency inspection. We don't get those today. There's a bill proposed, I believe Senate Bill 465, which used to be Senator Pileggi's Senate Bill 411, has taken up that issue quite strongly, and we support that aspect of the bill. But basically, it would give you access to the final results of safety inspection reports in Pennsylvania. You know, is the elevator you're working with properly inspected? What were the results of the inspection? Are the school buses that are driving your children around, are they safe to use? Have their safety inspections been approved, or are they not approved? Nursing home inspection safety reports, daycare safety inspection reports, all of those can be denied under current law, and we believe that has to change and should change for the betterment of Pennsylvanians. The thing with both of the investigation exemptions is that they contain no temporal limits. Once something is investigative in Pennsylvania, it's always investigative, regardless of whether the investigation has been closed for 50 years. And we saw this come up, I believe, last spring. A former police detective who was a family member, whose family members had been murdered 50 years ago, wanted to get access to the criminal investigation file for his grandparents who were murdered. And the state police said no. And the Commonwealth Court said, no, you don't get those because they're investigative, and they will always be investigative under Pennsylvania law. So even though everyone in the case was dead, including the person who was sent to prison and died there for committing the crime, even though everyone was dead, this file was still non-public under Pennsylvania law. And that doesn't make much sense to me as a public access advocate or as a citizen. If there is a need for secrecy, and many times there is, if there's a need for secrecy, it should be clearly articulated and should at a minimum make some sense, right? I mean, what's the point in having that grandson, former police detective, not have access to his grandparents' murder investigation file? I don't know. And it was never really articulated in the case. So there are certainly places where the law can be improved. And some of them are not based on the letter of the law itself, but with how the courts have interpreted it. So we've seen some decisions, the criminal investigation, the criminal incident report, for example, that's not a result of the right to know law as it's written. That's a result of the right to know law as it has been interpreted by the courts. So a lot of the things we'd like to see changed are a direct result of how the courts have applied this law. With regard to issues that I hear about frequently from reporters, the most common question I get is, why do I have to file a right to know law request to get something that I used to just be able to ask for and receive? And my answer is, well, you don't have to file a right to know law request. You can continue to ask, and the agency should continue to give you what they would normally give you. But I think, especially in the first, I'd say 5 years after the law took place, I think a lot of the local agency officials assumed that because we have this new right to know law, that it's now a paper-based process, everything has to be documented, it's administrative, it has to be, by the letter. And if it's not, then someone's going to get in trouble. And people obviously don't want to get in trouble. And that was a barrier for a long time, and it continues to be a barrier in some places because folks assume that because we have this, fancy new law, maybe it's not so new anymore, but we have this law that's very clearly written. I think it's fairly easy to apply, that everything has to be on paper and be documented, when that's not the case at all. There's nothing in the right to know law that says you must file a right to know law request. There's nothing that requires the agency to make you file a right to know law request. If something is clearly public, the right to know law process really just creates more work for everyone. Something that I do when I talk to legislators is advocate, not just legislators, but interest groups as well, like the townships and the boroughs and the folks we work closely with from the legislative perspective. We advocate proactive public access. Don't wait for folks to ask the question. Give them, if you get routine requests for X, Y, and Z document, make those readily available. Put them on your website if you have one. Getting access to government information shouldn't be a mountain to climb. It should be easy. It should be, I think that was the intent of the law, was to facilitate public access, to make it easier, to make it stronger so that we have a well-informed citizenry. Sometimes I think the mechanisms in the law really hinder that process. And we think that could be, I don't know that can be addressed legislatively, but I think it certainly can be part of training so that local officials understand, if a reporter comes in and says, can I see the copy of the superintendent's contract? There's no question that's a public record. Can you take out some tiny piece of information? Maybe the social security number in there, if there's one in there. Maybe a home address, although we won't get into home addresses here today. But there are things that are obviously public records, should be readily available, and shouldn't involve a significant administrative process, because that creates cost and work for the people at the agency, and it creates a delay and a barrier to access to people who want the information. So that's a lot of what I do, is try to help get people the information they need without having to hop through so many hoops on a regular basis.
For war stories.
I try to be.
For war stories, experiences, let's go right now to KYW News Radio. Kristen?
I have plenty of stories for the right to know requests. One of the most recent, actually just kind of coming off of what you said, One of the most recent stories that I have is we had Seth Williams, the Philadelphia district attorney, obviously indicted, convicted, sentenced, or pled guilty. And we wanted to know how much money the city had spent on his defense fund, because under the contract, under city rules, the city must pay for your defense until you are convicted of something. So we wanted to know how much that was. Simply enough, all I did was email the mayor's office and ask them how much did the city pay for this, and they gave me the information. And I was shocked that I did not have to file a right to know request. Shocked, because the city normally makes you file the request, wait the 10 days to tell you whether or not they're going to tell you how much, or whether or not they're going to tell you whether or not you're going to get an answer. And then on top of that, then you have to wait 30 days for you to get the records. So it's usually a very long waiting process, but we got it in, I want to say I got it in about 3 hours. And I was able to do a story that day. And so much of what we do as reporters, news is now, and especially with the way that social media has really taken over the news cycle, we need to know right now. It's not, we can't wait that 10 days, that 30 days, and then try and fight it out with them exactly what it is. So I was very thankful that the city was able to give us something so quickly. I've also, on the flip side with the city, have had spokespeople tell me that they get annoyed with my right to know requests. One in particular was recent. I asked for a certain do not call list that the Philly News had, or Philly.com had, and I got a kind of smart response of, I'm going to write to know request what you had for breakfast. And I then flippantly replied, well, the funny thing is that I'm not a public servant, so I don't have to answer you. But I was able to get it, and I was able to get it rather quickly, I would say. It was pretty much within the week, so that I just had it. It wasn't necessarily that I was going to report on it, but it was so that I didn't have to, as KYW, say that, it's the Inquirer's do not call list that they came out with this, although it really was their in-depth investigation that was able to come up with this information. So there's been a couple instances like that, but a lot of what I've run into is the specifics that I need to write out in the right to know request of exactly what I want. So I've gotten pretty good at that. I've written out, I would like this information for this day, this many pages, I will pay this much. It's very specific what they want, or they'll wait. I've also run into where they'll wait the 10 days to tell you that you're not specific enough. And then you're like, okay. So I have to go back and rewrite it and redo it, and so I've gotten that runaround. Just a tip, though, that has helped me is to call the office to ask who you exactly need to write the right to know request. Who is it that I need to write this, and what do you need to know from me of what I need to know? I know that's a little confusing, but you just want to be able to understand so that you can detail and you can outline exactly what you get, so that you don't have to wait the 10 days to know whether or not you're going to know the answer to the request in the 30 days, and that you're not wasting your time. I just get right to the point. I have run into, like you had said, I run into administrative assistants and whatnot saying to me, you have to fill out a right to know. And I said, I really don't on this one. I know that I don't have to fill out a right to know. And they'll say, and they'll argue a little bit back and forth. And I said, let me just talk to your manager if you don't mind. Just double check this. And then, usually they're incorrect that I don't have to file a right to know, that they can just tell me something. So that ends up being kind of a win. So I would say that training definitely is a big thing within government agencies, because when you don't tell me something as a reporter, I'm immediately wondering why you're not telling me that immediately. That's my job, is to question people and to question specifically any public official. It doesn't matter who you are to me. I will ask you the question. And some people and some public officials, I think that they're not subject to the questioning, which really makes me even more frustrated, many of us more frustrated. I think you would agree, Phil, right? So we just dig a little bit deeper, because it seems that there's something there that we need to dig deeper on. but I think that there's plenty of ways to go about how to find a right to know, how to find what you need to find, calling and just trying to figure out the best way to streamline it, really. There's different websites, for example, like FOIAmachine.org is one where they'll just pop up with, here's the right to know you need to fill out, and we're going to tell you when things are due. There's other ways to get around the exemptions. I belong to the investigative reporters and editors, and there's a way that we can call lawyers like yourself and try and get around the exemptions. I ask a lot of times for the criminal investigative, sometimes police reports and other things. In Philadelphia, it's a problem, more so maybe than in other counties, because they're very scared of witness intimidation. So I understand sometimes why they can't tell me things, but I try and do the best I can to kind of get around why I can't know something. And I think the best way is talking to an expert. If you ever have to find out, talking to a lawyer. We have lawyers on call. They'll just answer our questions because they are fighting that First Amendment just as much as I am. So they want to make sure that everything is within the guidelines of the law. So I've had plenty of experience writing it down.
Joe Conti from the broadcast world.
Well, thank you, John. It's a pleasure to be here today, and it's always great to be back in Delaware County and see some of my old dear friends that I enjoyed working with so much. And it's especially poignant for me this morning to be on the same team as John Baer. So that's an interesting experience for both John and I. So let me be clear. I represent as the president of the Pennsylvania Association of Broadcasters, we are the 38 TV, 368 commercially FCC licensed stations in Pennsylvania. So I do not represent CNN. I do not represent MSNBC. That's another entity and another association. I'm your local, our association is your local community-based broadcasters. So I think it's important to explain that. Our perspective on the law is it's been a good law for the 10 years it's been in. I think you're going to hear in future panels how good it is with some of the studies, and I think one of the clearest indications of that is the very low appeal rate that we have. But you'll hear more about that from more qualified people coming up. It's an exciting time in broadcasting because with all the consolidation that's going on, it's really strengthening our experience in handling the Right to Know Act. What I mean by that is our radio and TV stations are working with digital companies, are working with newsprint in a collaborative fashion, unexpected, unheralded, sort of unprecedented, and I think it's going to continue in that direction. So we find working with the law to be strengthened, if you will, by these consolidation efforts, and that's only going to continue, in our opinion. I think the two areas that I would urge looking at, we call the news cycle, they've marketed this as there when it matters, news cycle. Other people phrase it differently, but the public really wants the information like that. And when it comes to security, when it comes to weather, when it comes to safety, when it comes to terrorism, many times our entities are the ones you go to first. So the couple of areas we think that might need some amendment, and I have not studied the new Senate bill, hopefully they can look at this, would be in the area of the time frame, of course the 5 and the 30, which is really in essence the 35-day, which is the way most agencies handle that. Remember, I have another whole set of remarks when I was the CEO of the Pennsylvania Liquor Control Board about Right to Know. They're in this pocket. I pulled out the right remarks, so, but because every request there was a hostile request, if you will. But so if we could look at the time frame, I think we do have to look at security. In today's world, which is a different world than just 10 years ago, there may be reasons where we may need some different levels of information as it relates to security, terrorism, school safety, weather, and those kind of things. So that's basically the perspective of our association at this point.
And I'd remind you, if you have questions, and I hope you do, there are cards, write a question, pass them to the ends, and somebody will pick it up. But for now, observations from the heron nest.
I probably should go in where I place that I'm almost every day these days in the confessional and remind Joe that he is, in fact, sitting next to the state's foremost proponent of blowing up the LCB and getting the state out of the booze business. But it's interesting in terms of the people who are here today and in this sort of cross-section of the idea of government officials and news people and our interactions with each other. And the saying is that all politics is local. Well, I can assure you that the same goes for the news, especially in the areas of local community newspapers. That is our bread and butter every day. Our aim is to tell you what is going on here in Delaware County. Sure, we'll tell you, and give you a review of what's going on across the state and the nation and in the world. And we'll keep track of the president's Twitter account for you. But our focus is always going to be here in Delaware County, which means we deal every day with 49 municipalities and 15 public school districts. And I can tell you that for the most part, before this law went into effect, and in some instances since it has been in effect, that some of these local towns and municipalities and some school districts really amount to almost a local fiefdom. This is the way business was done in these towns for a long, long time. Some people controlled what information was released, what information was not. I can tell you that there probably is not a reporter in the state who has not dealt with a situation where they were chasing a story on a Friday and they were trying to get a hold of some information from the police, and they'll call and they'll talk to an officer, and the response is, that information's only coming from the chief and he's not going to be back until Monday. Those kinds of things are things that we deal with all the time. One of the areas that you may or may not realize that almost everything that we write in terms of police news, and we don't call us the Daily Crimes for nothing. We deal with police news thoroughly every day. All of that information is based, for the most part, on a document called the Affidavit for Probable Cause, which is always filed when an arrest is made in a case. And it's incumbent upon us, either from the police department or from the local magisterial district judge, which is the person's first point of reference after the arrest in terms of going through the judicial system. So we'll go to some of those courts, and we still, to this day, have some local courts that are sort of balk at that, and you remind them of the law. And then, of course, something that's already been mentioned and is the bane, and is probably as much our fault as anyone else, is that a reporter will be writing a story and will need something, and they'll call a police department or a municipal office, and they'll ask a question, and they'll say, when you need it, and they said, well, my deadline's in 5 minutes, so hopefully you can get the information to me soon. But this idea of time and money certainly play into this aspect, and the idea of how long it takes to process information. But in terms of, aside from the areas that have already been looked at, some of the areas that I think are really going to come into focus down the line, one area that I think is just going to explode and be ripe for this kind of discussion is, let's face it, does anything happen in our lives that is not captured on video? You walk into a store, you're on video. You walk up to an ATM, you're on video. Well, guess what? I think in the very near future, almost most of the interactions that you have with a police officer is going to be captured by that officer's body cam. And I would certainly be interested in knowing how the law will adjust and how open that'll be in terms of access to that video. But
I can answer that if you want.
Sure.
We had a law that was passed last year, Act 22, that removed law enforcement audio and video from the right to know law. So you can't get access to it under the right to know law.
That's my understanding, yeah.
There's this new parallel burdensome process that I have yet to see result in access here in Pennsylvania. So despite the fact that that video is regularly being captured by government agencies, I think the public has a significant problem in getting access to it under current Pennsylvania law.
And it's sort of a follow-up to that is that video that is I guess would be public, although it would certainly be private. Almost every store now has video. When that video then becomes part of an investigation, is that fair game?
Under the investigation exception in the right to know law, probably not, although like Senator Pileggi said, agencies have considerable discretion to release what records may be exempt, so they can go above and beyond that basic, we have to give you this minimum information and provide more. And some agencies do, including law enforcement agencies, some do. Many do not. But the moment it becomes evidence in a court of law,
Right.
We're not looking at the right to know law anymore. We're looking at access under the Constitution and common law, and it would be public there when it's introduced as evidence. So you may end up waiting a little longer to exercise your rights under this parallel access mechanism under the Constitution.
Or you can go to the store owner, the clerk owner himself, and get your own copy, which I've done.
Yeah.
Okay, before we go to questions, anybody have any rebuttal or anything they want to add to whatever they said? Or we're good?
I just wanted to add one thing. A little bit on what Phil said. I thought it was, just because it's all in our recent mind, the Wildwood, did everyone see the Wildwood video of the police officer? That was something that Wildwood Police just put out. They were open about it. The investigation obviously is continuing, but I thought that was something that was very helpful to the public, just to have that immediately, because we had just the one cell phone video from the other person that was lying on the beach, and then we had this video that was put out pretty immediately. I think it was within like 24 hours of it happening, which I would encourage police officers to do in the future.
2 quick points. In Joe Conte's reference to he and I being on the same team, meaning media and press, on his way out, Governor Rendell stopped me and said, "Hey, I was looking through some old clips last night, and I came across a column you did where you actually said something nice about somebody in government." And I said, well, it must have been a bad day. And with regard to, in the earlier session, Phil talking about the public interest in public salaries, you should know, if you don't, that there is now something called Penn Watch, in which you can look up the salary of every single state employee. And the Harrisburg Patriot News does this on an annual basis, and they publish a long list of those making 6 figures. And I can tell you from personal knowledge that there are political employees in the legislature, staff more than anybody else, who strive to stay at 99,000 so that they don't make that. These are the 6-figure public employees that you fund. Okay, a question maybe, Melissa. Regarding criminal court records, isn't information available on the state unified judicial website?
Some information is available, and we just saw some significant changes to that system at the beginning of the year and again in April, and there'll be new rules taking effect in July 1st. There is a significant amount of information available at the courthouse, less information available online, although still a significant amount. And the court has implemented these new rules regarding confidential information, so there will be some information that was public before these policies took effect and are no longer public today. This is a separate process from the right to know law. So the way the right to know law kind of interacts with this is the fact that many times an investigation doesn't result in charges or doesn't result in a prosecution, and in those cases, the public is left to wonder why, because there's nothing filed in court. So, and if the criminal investigation exception in the right to know law is the only applicable law, it's very difficult to overcome from a public access perspective. So, oftentimes, what I hear from reporters is, well, we know the DA did an investigation, we know the police officers were investigating this subject, this alleged crime, and nothing's come about from it. What can we get? And my answer is usually not much under the right to know law. So people are forced to wait until they can exercise their constitutional rights to access court records, because the right to know law really isn't helpful. And that's one of the places I tell journalists, if you're dealing with access to criminal justice records outside a court of law, it's best for you to try to have a positive working relationship with your local law enforcement agency so they understand your role, so they understand their role in the community and their responsibilities to provide accurate information. But it's one of the places that I say the right to know law is a hindrance rather than a help.
I'm not entirely sure what this question means. I think I know. If the asker would correct me if I'm wrong. I lost track of this issue, which has been working its way through the courts. Does the open records law require disclosure of government employees? I assume you mean financial disclosure. Or
disclosure.
Oh.
Do you have to tell someone?
Identifying information besides their name, title, and salary. I'm thinking about their address and birth dates, which one court had said must be disclosed. I was writing this, as I was writing this, Melissa said something about not discussing it, but I'll ask anyway. Yeah, I was going to ask anyway, too. Why can't we discuss home addresses and stuff?
You certainly can. And there are folks I see in the room who will disagree with me on this reasonably. I mean, reasonable minds can disagree. So a few years ago, I think it was 2015, the Supreme Court in Pennsylvania found that there is a constitutional right to privacy in personal information. And that case dealt with access to home addresses of public school employees. So we have this concept of personal information, but we don't really know what that means because the court hasn't told us what personal information is. Home address is one of the areas where the court has said an agency must conduct a balancing test to weigh the interest in privacy versus the interest in disclosure. So it doesn't mean addresses are never public, and it doesn't mean they're always public. It means the agency has to balance. And in some cases, and I know the OR has ruled the interest in public access outweighs any interest in privacy. I take the position that where there's a statute that specifically grants public access to home address information, like voter registration records, for example, there the public interest in privacy, or the interest in privacy is far outweighed by the public interest in disclosure. So the general rule is, well, I don't want to say there's a general rule. The Supreme Court has told us with regard to home addresses, at least with regard to current public school employees, agencies have to conduct a balancing test and determine whether or not interest in privacy outweighs interest in public disclosure. What else falls under this umbrella of personal information remains to be seen and kind of ferreted out by the courts, but I've seen agencies cite everything from name, job title, and salary as personal information subject to balancing to social security numbers, which are already non-public under both state and federal law. So I think there's a lot of confusion about public address or home addresses. I think there's a lot of confusion about what personal information actually means. With regard to dates of birth, we have court cases that say there's no blanket exemption in the right to know law for dates of birth unless you're talking about minors. But with regard to dates of birth, we have court cases where, again, it was kind of a similar balancing test was employed, and the court said there's no blanket exemption, but you have to conduct this balancing test. In some cases, month and year will be okay, but not the full month, date, and year. Again, it's got to do with what's the public interest and what's the interest in privacy. I mean, obviously the concern is identity theft, were the issues that were articulated in those cases. The court system, if we're talking about the parallel access under the Constitution, the court system, if you're dealing with access online, is typically, it depends on which one you're dealing with, but the MDJs is usually month, date, and year. Sometimes it's just month and year. If you go to the courthouse and actually look at the files, it's usually month, date, and year. It's the full date because the courts like to talk about this concept of practical obscurity. If it's not online, nobody's really going to see it anyway. So it's left undisturbed in the formal court records because I think that's what the Constitution requires. But then when they put it online, they're going to scrub a little bit of that information out to make it more difficult to use for nefarious purposes. But that also makes it more difficult for someone like you to use for legitimate purposes.
I always see the date of birth in the Philly court system. That's always there.
Yeah, there are a few different systems.
Probably because there's so many people.
Yeah, I mean, and that's one of the reasons that media members need it, is to identify people and not misidentify others who are accused of a crime. There are 400,000 John Smiths in Pennsylvania. You don't want to be sued by.
I know Meek Mill's birthday because his name is Robert Williams. So I know, so looking at Robert Williams, there was a million Robert Williams, and I know his birth date so that I know I'm talking about the right one.
And if you misidentify and you say it's Robert W. Williams when it's really Robert F. Williams, Robert W. Williams can sue you for defamation easily and win. So accuracy is a big part of why we need that information. And why we seek it. I mean, I don't know any of our members that have ever used that information other than to identify someone.
It's mostly based on age. I mean, I just take a calculator and go, wait,
Yeah.
John, can I give an anecdote, very quickly, because I know
Sure.
I don't want to monopolize. When I was at the Liquor Control Board, our Director of Regulatory Affairs said, I need to see you with a new hire. And he came into my office, and a gal who had just started as a licensing agent, and it's pretty tough to go through civil service and get the job, and my recollection was it was about a $24,000 a year job. And I think it was the Patriot, I forget who it was, one of the papers that Friday after she was hired printed all the salaries of all the employees working at the PLCB. So she goes to her church picnic Sunday, and of course everybody's saying, oh, I see you're making $24,000 your new job at the LCB. And she was basically sort of in tears about that. And I guess now that's a 10-year-old, 12-year-old story. As we go down life's path, when you're in government at the high levels and you file your ethics forms, and you kind of know everything you do is subject to public knowledge. Everything, literally everything. Now I think the world has changed where we actually have to explain to the newest member of a township road crew, to the newest policeman in a borough, and to any higher state government, the same thing. Because it is tax dollars, and I think we do have a right to know that, but I think there has to be a better job done by government at all levels in Pennsylvania, explaining to everybody involved that there are new responsibilities, if you will, when you participate as working for government. So I just share that as an anecdote. Maybe that's the flip side of all the prior discussion, but there is a human touch there that when you go to your school picnic or when you go to your church bazaar and people know what you're making. And
I'll go into that, John, in one sort of gray area, sort of somewhere in between, which we are still trying to get a delineation on. And that is that there is an entity, a really growing entity, and apparently a very profitable entity out there called charter schools. And these charter schools, in our view, get an awful lot of your money that goes into their operations every day. And so we think it would be nice if we knew what they were doing with that money, but actually, really what we want to know is how much money and how much they are making. And their reply is, oh no, we're a private entity and not subject to the state's right to know law. And I'm telling you, we've been going around and around and around on this for more than a decade, and it is still, I sometimes forget about it, and then I'll get a phone call with the latest update on it. If you don't know, Delaware County is home to the state's largest charter school, right here.
Time's up, kids. Phil, Kristen, Joe, Melissa, thank you very much. Thanks to the center. Thank you guys.
Joe?
At this time, the afternoon session will first start with the financial implications of the law. The executive director, Patricia Berger, and analyst Louis Day are here to provide an overview on the recent status and the reporting of the financial impact of this law. Folks, come on up.
Good afternoon. My name is Patricia Berger, and I am the Executive Director of the Legislative Budget and Finance Committee. Thank you for inviting us today to discuss the cost to implement the Right to Know Law report the Legislative Budget and Finance Committee released in February. With me today is Louis Day, an analyst on the study. House Resolution 50 of 2017 directed the Legislative Budget and Finance Committee to conduct a comprehensive review of the fiscal impact on state and local government agencies for implementation of the Right to Know law. The review was to identify the annual cost to state and local agencies for administration of the law and actions to decrease the administrative burdens of the law on state and local agencies while ensuring reasonable public access to public records and information. In general, we found that most of Pennsylvania's state and local government agencies receive few right-to-know law requests. Most of the requests are easily fulfilled at a relatively low cost, and only a small percentage of the cost of the requests are appealed. However, Some agencies, large and small, do receive a large number of requests, often for a commercial purpose from outside of Pennsylvania, which could be both voluminous and time-consuming. Now I'm going to ask Louis to provide more details about our work and our findings.
Thank you. In our analysis, we distributed 2 separate surveys to approximately 2,800 agency open records officers, or AROs, for Pennsylvania state and local government agencies to identify the number and type of right-to-know law requests they receive and the costs incurred. One of the surveys was very brief and only sought to measure the historical trend for the number of right-to-know law requests received each calendar year from 2009 to 2016. The other survey was an extensive questionnaire that sought detailed information on the right-to-know law specific to calendar year 2016. For each survey, we received approximately 1,100 responses, although the number of responses varied for certain questions. Based on our survey results, we found that the overall number of right-to-know law requests received by Pennsylvania state and local government agencies has steadily increased since 2009, with 95% of the nearly 1,100 responding agencies reporting that they received at least one request during calendar year 2016. However, the number of requests received and the costs incurred differed significantly among agencies. Although more than 3/4 of the agencies received fewer than 25 right-to-know law requests during calendar year 2016 and incurred annual costs below $2,500, approximately 10% of the agencies received over 60 requests and reported incurring annual costs ranging from $10,000 to over $400,000. Based on 2 separate calculations, we estimate that the total cost to state and local agencies to process right-to-know law requests during calendar year 2016 was between $5.7 to $9.7 million. We also found that fewer than 3% of the right-to-know law requests received by our survey respondents were appealed to the Office of Open Records, or OOR, or the courts, and only 16% of the agencies surveyed reported having any requests appealed. Additionally, fewer than 4% of the agencies accounted for 80% of the total appeals reported. This suggests that most agencies incur little to no cost responding to right-to-know law appeals, but a relatively small number of agencies likely incur significant costs responding to a large number of appeals. Unfortunately, few agencies were able to provide us with their estimated annual costs for responding to the right-to-know law appeals, and as a consequence, we were unable to estimate the annual costs incurred for appeals. Since the right-to-know law went into effect, agencies have consistently reported an ongoing issue with a large number of exceedingly time-consuming right-to-know law requests that they consider overly burdensome, especially commercial, litigation, and inmate requests. We found that almost 18% of the requests received by our survey respondents were identified as overly burdensome. However, there is little consensus among agencies on how time-consuming requests must be to be considered overly burdensome. For example, 1/3 of the requests considered burdensome were fulfilled in less than 3 hours. 1/3 were fulfilled within 3 to 8 hours, and the remaining 1/3 required 8 hours or more. Therefore, whether a request is considered a burdensome appears to be highly dependent on what the agency perceives to be burdensome and may be more directly related with concerns about the type of request being made or who is making the request. Although the majority of the requests received by our survey respondents were identified as being made by individual citizens for a general purpose, over 1/3 of the requests were identified as being made for commercial purpose, mostly from out of state. 10% of the requests were identified as being related to litigation against the agency, and 7% of the requests were identified as being made by inmates. However, few agencies reported receiving inmate requests, with the Department of Corrections receiving over half of all the reported inmate requests. There was also little variation in the amount of time spent responding to the different types of requests, with roughly 2/3 of all general, commercial, discovery, and research requests and 89% of the inmate requests being fulfilled in less than 3 hours. Although most agencies receive few right-to-know law requests each year, and most of those requests can be fulfilled in less than 3 hours, a relatively small number of agencies receive a large number of commercial requests and other exceedingly time-consuming requests, which could become a financial burden for some agencies. Therefore, our report recommended to the General Assembly to consider specifically authorizing the Office of Open Records to establish reasonable hourly fees as they determine necessary for commercial and other exceedingly time-consuming requests, as is done in other states. There are concerns, however, that some agencies may incur costs, unnecessary costs, because they fail to use processes that would reduce the time spent responding to right-to-know law requests and undergo legal costs by sending most of the requests to their solicitor for legal review, or by responding to otherwise avoidable right-to-know law appeals. For example, many agencies have reported sending most, if not all, of their requests to their solicitor for legal review, and 34% of the requests received by our survey respondents were reviewed by their solicitor. It is likely that many of these requests did not require a legal review, and therefore agencies may have incurred unnecessary legal costs. The use of solicitors to review simple and routine right-to-know law requests is likely a key factor in the high costs some agencies have reported complying with the law. We also reviewed the websites of 588 randomly selected state and local agencies and anonymously contacted each agency to verbally request that they email us their annual budget. We found that only 33% of the agencies posted their annual budget on their website, and fewer than 60% fulfilled our right-to-know law request by the statutory deadline. Most of the other agencies never provided a response to our request. However, several agencies refused to fulfill our requests because we would not specify who we were calling for, why we wanted their budget, or what exactly we were looking for in their annual budget. Many of them were confrontational, and 3 agencies immediately terminated the call. Although we did not appeal any of the requests that were deemed denied, these findings support the claims that some agencies may undergo unnecessary legal costs responding to otherwise avoidable right-to-know law appeals. Although the majority of the sampled agencies were aware of the requirements of the right-to-know law and responded to our right-to-know law request by the statutory deadline, we found that some of the agencies were unfamiliar with the law. Until recently, the training courses provided by the Office of Open Records have been primarily through on-site presentations when requested to do so. But the Office of Open Records has indicated that the office has had difficulty meeting the demand. This also requires travel by the OOR trainer and to some extent the attendees, and therefore it is likely that some agencies have not attended the training sessions due to time and staffing limitations. For this reason, the Office of Open Records has begun using webinars as part of their training program. However, the right-to-know law does not specifically require agency open records officers to participate in the training sessions offered by the Office of Open Records. The lack of training may result in inefficient responses to right-to-know law requests, unnecessary solicitor reviews, and otherwise avoidable appeals. Therefore, our report also recommended to the General Assembly to consider requiring all agency open records officers to annually attend one Office of Open Records right-to-know law training course, either on-site or online. And we also recommended that the Office of Open Records develop electronic training and informational materials for both agency open records officers and right-to-know law requesters to provide ongoing training throughout the year. During our review, we also found that 70% of the sampled agencies were not in full compliance with the statutory website posting requirements of the Right to Know law, with over half of those agencies not posting any of the required information. Although not required by law, we also found that less than half of the sampled agencies had any of the Right to Know law information posted in an easily accessible location on their website, and about a quarter of the agencies provided complete contact information for their agency open records officer. Therefore, our report also recommended to the General Assembly to consider requiring agencies to prominently post the required Right to Know law information on their website, and to specifically define agency open records officer contact information to include the officer's name, telephone number, email address, and physical address. We also found that the list of agency open records officers maintained by the Office of Open Records was outdated and incomplete. Therefore, we recommended that the General Assembly consider requiring agencies to provide complete agency open records officer contact information to the Office of Open Records annually or whenever there is a change in the information. We also recommended that the Office of Open Records create a searchable database on their website for the contact information for all state and local government agency open records officers and update it as new contact information is provided by the agencies.
And in closing, we acknowledge the assistance we received from the Office of Open Records Executive Director Erik Arneson and his staff, the numerous state and local government agencies and their representative associations, the various associations that advocate for government transparency and access to public records, and several individual Right to Know law requesters. Also, quite a number of the folks who presented today or will be presenting are folks that we did talk to during this project. There are several hard copies of our report available at the registration table. If you would like to take one with you, please feel free. Otherwise, they are posted on the Legislative Budget and Finance Committee website, or if you contact our office, we're happy to send you a copy. Our reports are actually specifically listed in the law as a legislative record. So we're happy to provide them. So thank you for your attention, particularly as we're at that time in the day when blood sugar levels may be low and you may not have had enough to eat. So thank you.
And believe it or not, we have no questions of the report,
Okay.
folks, so thank you.
Thank you. Oh, I'll give you the quick introduction then. Sorry about that. The Legislative Budget and Finance Committee is a statutorily created committee of the General Assembly that is both bipartisan and bicameral. There are 6 House members, 6 senators, 6 Republicans, and 6 Democrats, and our officers represent the 4 caucuses.
Thank you very much to both of you. Thank you. And at this time, we'll be hearing a view from the other side. And a view from the other side being the panel discussion with local government and council in solicitor roles, typically, to talk about the possible misuses of the Right to Know Act. So of the folks that we have here, we have Doug Hill, who's the Executive Director of the County Commissioners Association of Pennsylvania, Elam Herr, Assistant Executive Director of the Pennsylvania State Association of Township Supervisors, and Frank Catania, Esquire. Good afternoon, gentlemen. First and foremost, we are here to talk about a view from the other side, meaning those folks that receive the Right to Know requests. So starting with you, Doug, if I wouldn't mind, what are your thoughts on that?
Sure, thank you. Well, first, it's great to be here, and I wanted to comment on the title, The Other Side, because we aren't really the other side, we're the other perspective, I think. In point of fact, and this might be counterintuitive for some of you, our association actually supported passage of the legislation. We worked closely with the Pennsylvania News Media Association Erik Arneson and others in getting the legislation drafted in a way that fits our needs as well. And the reason we supported was because at the time we were working under the old open records law, which was written, I think, in the 1950s, before electric typewriters, let alone computers and all the other things, types of records that we were dealing with. And so it was important to us to receive some level of guidance in how to deal with the new records regimens, the public interest, and all the rest of the things that had changed in the 60 years since the prior law. And more importantly, to do it in a deliberative way with the General Assembly rather than waiting for the courts to rule piece by piece by piece by piece and set how we were to do it. Counties also have a history. I mean, that's what we were incorporated to do: deeds, wills, mortgages, election records, and all the rest. And so our doors always had been open for the most part. Granted, there's things relative to contracts and employee matters that are always going to be subject of needing some statutory guidance. I also want to mention, too, that after the law passed, Elam and I and Terry Henning, who at the time was with the Pennsylvania News Media Association, did a statewide tour, and I think we did 6 or 8 28? Okay, 28 different training sessions. It's been a while. Maybe I'm blocking it, I don't know. But training sessions all around the state for all of our members to come in, ask questions, get a perspective immediately after passage on what our vision was for this law going forward. The primary issue for us, too, is, and I'm sure you heard in earlier presentations, and I apologize I got here late, but this changed the presumption under law. Prior law was that everything was closed unless the law said it was open. This says it's all open unless closed. And so that meant a couple things for us. First, we had to be very careful and deliberative in how we carved out the exceptions. There's 30 of them basically listed in Article 7, but then there's also procedural and some other things as well. And secondly, we had to be very clear about striking balance, because as governmental entities, we have two distinct responsibilities. One, certainly to let the public and the media and others know what we're doing and be able to watch what we're doing, but we also have to guard the privacy rights of individuals, and we also have to guard the processes and the services that we provide so that we can do it properly and not jeopardize the service that the public expects to receive for their tax dollar. I'll mention one thing that we didn't quite expect with the change in burden of proof, and that was the volume of 2 classes of requests, and of course we just heard about from the LBFC on some of that, but commercial requests, and those typically tend to be either the trial bar or realtors. So give us all your cases related to this issue, this matter, or give us your full list of properties that fit this particular class, might be in danger of tax sale, something like that. And then prisoner requests. Of course, counties do the county jails, and if you're confined for up to 2 years and you're looking for something to do, here's some things that I'd like to look at a bit. And so that's something that we might need to deal with a little bit more. I also want to commend, and I think someone did earlier, Terry Muchler, who was the original director, and also Erik Arneson, the current director for the Office of Open Records, because they have come in with not an aspirational approach, rather, as in, here's how we'd like the law to read, but rather, here is how the law reads. And they've made sure that their staffs have had a remarkably balanced and grounded approach in interpretation of different elements of the law. And I think the last thing I'll note is that we are now at the 10th anniversary. We have seen how it's played out in the years since passage. 5 years ago, legislation got started to try to address issues on both sides. That legislation is still pending, and that's something that we're still committed to pursue to make sure the law operates as intended and operates in a fair and balanced manner for both sides. Thank you.
Elam, the Township Supervisor perspective.
Thank you. First, I would like to thank the Center for Leadership for having this conference today to put all the different groups together. It's something that is definitely needed. I will say, and I'll keep my remarks short because basically whatever Doug just said, I have to agree with, except where he talked about typewriters and that. Actually, when we started, we were still using chisels and stone for how we kept records. Doug is correct. We did work with all entities when the act was, or the bill was being discussed. And you heard from Senator Pileggi today, and I give Senator Pileggi a lot of credit, or Judge Pileggi, I should say, at the time, Senator Pileggi a lot of credit for where we went. He instructed his staff what to look for to be both impartial and look at both sides of the issue from our perspective, because we have the records, and we do agree with the concept that all records that are to be open should be open. But he also said from the other side of the perspective, which you heard a little while ago, that you have the right to this information that government agencies have. With that being said, Doug and I were the two that represented local governments on the negotiations, and literally when it was all said and done, good, bad, or indifferent, the way it's been interpreted, both organizations did support this legislation. I just gave Senator Pileggi some credit for getting this through. My one objection that I have to Judge Pileggi is he left the legislature a little too soon before the amendments to this law, which we have been working on for the last couple of years, again, with the other side, did not get through. Luckily, we got it through the Senate, but it was tied up in the House, and to this day, that's where it has been. Concerns from our members, first of all, from the news media, that's not a major concern. We thought so at the time that the request would be coming in. It really hasn't turned out to be that way. As Doug said, the biggest problems that my membership has had is the commercial request. And a lot of times the commercial requests aren't even coming from within Pennsylvania. Now, we agreed at the time because of federal law that it should be requests coming from throughout the country, but we have seen now that the requests coming in are just overburdening our municipalities. Also remember that my membership ranges from less than 100 population, very small townships, to over 60,000 population. And the smaller ones, if they get some of these requests, totally can shut down their operations. And as Doug said, from where the county gets the request, we get requests just building permits every month. And they ask the request for, and in a specific matter, the law says that you don't have to make a record, but it does take time. I just recently heard this year, to date, 66 requests to one municipality, one township, which has taken over 120 hours to fill those requests. Now, a lot of my members also don't get any requests during the year. Others who don't report requests are such that, as in the minutes from the previous meeting, once they're adopted, they have them out available, or you come in the next day, they give them to them. They don't classify those as a right-to-know request. Theoretically, it is. They're requesting a public document, but it works. So what our membership would like to see are some improvements back put into the law. One would be, again, the commercial request, excessive time-consuming request. Usually that comes from an individual in the municipality for whatever reason, constantly ask for almost the same thing, and you got to comply with it. And financial information. The act is a little confusing in some financial information that it has to be made available. And although, and I will stick up for the Office of Open Records, I think they would agree with us, but literally any one of you could go into a township and ask for the bank account numbers, the routing numbers, and the PIN number for the bank account. Now, unless you want to borrow some of their money, why do you need to know that information? Our members will deny that request. If you have more money than brains, you'll appeal to the Office of Open Records. I think the Office of Open Records would definitely say no to it. And if there's, you still have more money than brains, you'll appeal to the courts, and the courts would side with us. But why should you, as taxpayers, have to pay for something that, should be changed? So, is the act working? I would say yes. I think Doug would agree with me, and I think the previous panel, in most cases. Does it need improvements? Yes. After 10 years, it's time to revisit it and get better ability to make information, public information, that information which is needed, available. Thank you.
Thank you.
Council?
I wanted to join my colleagues in thanking Neumann University for hosting this important topic today, and hope that our continued dialogue can lead to those much needed amendments in the right to know law. I will speak from my experience with representing and making requests from boroughs and townships and cities and municipal agencies and school districts. Their initial reaction to the passage of the law and the reversal of the presumption was that this is a new administrative tasks and there's no funding mechanism for it, so we have to spread the cost of this over our already general fund, and we're already under pressure there. In the past 10 years, the larger governmental entities, local governmental entities, have handled that burden better than others. And the more successful ones are the ones that have streamlined and formalized their responsive process. They keep a log. They have letters ready to go. They're cognizant of the same kind of requests that come in every single year, and they have those pre-packaged requests for refunds that haven't been SG'd, payrolls, employee listings, so on. They will also know locally that even years are easier than odd years, because odd years are election years, and the opposition research gins up around January of each year. But they have benefited more from a streamlined process, and that's something that some of the smaller communities can benefit from. And since Erik's here, I'll ask that his office give some consideration to perhaps working with the Pennsylvania Historic and Museum Commission and making more available sample retention policies. I've seen some of the state agency policies that are very current in terms of what is to be done with social media and digital media that is created by employees or elected officials, and they allow a certain amount of employee or elected official self-policing that local governments aren't even aware of. But the biggest complaints that I hear are that this is an unfunded mandate on the smaller governments, and we should get some kind of relief, both in terms of funding and in terms of who the requests come from. Similarly, there are requests depending upon what governmental entity request from prisoners, but mostly the commercial requesters that ask for lists of unpaid bills, unobtained refunds, so on. The question that I get most often, and I'll pass this on to the previous panel, is, and I don't have the answer, but why is the legislature exempt from the right to know law? I know it's not fair to ask this question when you're in the audience and not up here, but I will say that I hear that most often from my colleagues. I'd be happy to answer any question or share any experiences.
Sure. So dovetailing on the first part of the conversation, we'll leave the second one for maybe a little bit later. But what consideration, this is from the audience, what consideration was there for the amount of manpower required by the many small municipalities to follow through? And when we're talking about the amendments and we're talking about some changes, are there any discussions in there about future subsidies planned to reimburse municipalities for salaries necessary for officers?
When we were discussing the reversing that all records were available, at the time we did not have any concept of what would be requested. Over time, we have learned about the commercial request, this request that can come from an individual who, for whatever reason, has excessive demands. We have been working previously. Senator Pileggi had mentioned Senate Bill 411, which has had a provision in it where the agency could charge a fee, and we agreed through the discussions that the lowest paid office personnel who would be able to get the information together would be the fee that could be charged based on their hourly rate, so we could start to recoup some of this money. There was also a provision in there, and I think it was the first hour would be free, so that if you as a citizen would come in and ask for a simple request, you wouldn't be charged for it. But if you came in and asked for a voluminous request, you're going to pay for it, and the taxpayers would not have to foot the entire bill. One of the other issues to address part of this problem is, and the Office of Open Records sets the fee that you can only charge 25 cents per page. What happens, and there is a case from the central part of the state, an individual came in and asked for all these documents at 25 cents per page. It was several $100s. When he came in and found out what the cost was, he said, I don't want to pay that. I only want to see pages 1, 3, 5, and whatever. We can't have that. If we have to go through this process, the requester needs to be able to pay. Another provision in the law would lower the amount from $100 to $50, that once you get over it, the requester would get over $50 estimated cost, he would have to pay the fee up front. So we did look at, and we are looking at, and we've discussed this with Erik, to try to address the issue of excessive cost. This won't only benefit the small municipalities. This will benefit any municipality that gets a voluminous request.
Another question, how do you handle repetitive requests at the county commissioner level, township, as well as solicitor? Right.
Sure. Repetitive requests are a little bit more difficult because the law, as written, is repeated request for the same or very much similar record. And so those are easy to turn back. The harder ones are prisoners, the requests for sequential information. Okay, I got that, now get me this, and now I got that, get me this. And so that's where it gets a little bit more difficult to say, this, in our judgment, this is being done simply to harass the office or to try to keep us from doing the rest of our job. And so is there a way that we can have some judicial finding that this particular, the nature of this request and the purpose of this request isn't really for information, but rather to try to thwart governmental operations? But that's a very, very difficult line to draw, and we recognize that, and so that's why the law is written as narrowly as it is at this point.
If the request is exactly the same, most of my clients would give the same answer the second time as they did the first time. There is a provision in the law, as Doug says, about how to handle those sorts of requests that are burdensome and not really designed to solicit responsive records, but simply to harass the Office of Open Records officer, and that's pretty easily dealt with.
How often have you utilized that?
Not very often with me. I haven't seen it much, and I don't even know that I've seen cases on it. Maybe perhaps I've won. So, I mean, look, some of the open records officers, view 30-paragraph requests as burdensome, and they are. But I don't think I think at this point there's a majority acceptance of the substantive need for the law. Most of what we're trying to work through in local government is, what's the administrative burden and who should bear that burden.
Sure.
And the real issue there is that, when a law like this passes, one of the consequences of it is that that local governments and state government should change how they keep their records to enable them to respond to the law better. And I don't think that's been happening at all. I think that's the real underlying thematic problem here.
And I'll follow up on that point as well. And LBFC in their report was talking about some of the burden is self-imposed. And that was one of the things that we really tried to hit on in training. Elam alluded to it here in his earlier remarks, is a lot of this is pro forma. You've been doing it forever. Someone wants the minutes. Don't make them file a piece of paper with an open records officer. Just put it on the desk and they can pick it up. And that's the encouragement we've been trying to do with our members. But we do have some, inevitably, that take a very strict legalistic approach. And so, yes, everything has to be a file copy with our open records officer, and then we'll handle it from there. And oh, by the way, because this looks a little bit different than anything else, we're going to do a pro forma 5-day request for our extra 30 days. And so don't tell my members this, but it's hard for me to be too sympathetic for them to say this is a burdensome statute if that burden is self-imposed in that way. The other side of it, though, we did try, and again, recognizing electric typewriters, we did try to write into the law, there's very specific language that if it's in electronic format, our simple response can be, here, go check out this website, or go check out this particular thing, or here's an email filing. And then, of course, a requester, if they need it in paper, can request it in paper. But the bottom line is, for our side, we can expedite it. Now, I'll follow up very quickly on Frank's comment about the records retention. And you'll notice 2 places in the law it actually says nothing in this law changes records retention schedules. And that was purposeful because we also knew, because as Frank says, it's self-policing in a way, particularly for things like email. We didn't want to be caught in that situation where we get a request for a record. Oh, well, we deleted that under the records retention schedule. Oh, you deleted the record, so you're trying to hide something. No, it's the records retention schedule, period. And so that's one aspect of it. The other aspect is one of the earlier panels talked about practical obscurity. Those of you who have been to the courthouse and gone particularly through judicial records, you can go in and pull the big volume out and start leafing through, and you're going to find Social Security numbers all over the place. We were not required to proactively redact all of that information. And the point being, someone who wants to commit some mischief, that's going to be pretty burdensome on them to go through and do it that way. And so that's why we have some dividing lines on electronic access. Property tax records are probably the best example. A lot of counties very bravely put their whole assessment records, set of assessment records online, and then just as quickly turned around and pared that back a little bit. So you could still see the address, you could still see a picture of the property, but you didn't get all the information on the owner and all of that. So you could still do your public thing, which is compare these properties to yours, but at the same time we had essentially redacted some of the information, and on the other side of it, made the information more conveniently available to the public. So those are some of the kinds of strategies that we're, I think, all still working our way through.
Sure. One last question this is from the audience. How, in your opinions, obviously it's just your opinions, would various levels of government feel about the mandatory training recommended by the Legislative Budget and Finance Committee?
The elected official, or the person that has to go to the training? The elected officials will be in favor of it. I think it's a good idea, frankly, and I think most of the open records officers that I work with would relish the opportunity.
Yeah, I think I would agree as well, and I think that also gets to the point we've just been making, and that is for those who believe this is how far you have to go, they'll find some comfort in the training that, no, this is really a more practical approach, and the training, I think, will help confirm that.
Yeah, and just to follow up, though, just so everyone here doesn't get the impression that no training is being done, the Office of Open Records under Erik and preceding him, Terry, did conduct and does conduct training sessions. We work closely through our training division with the Office of Open Records, so we put on training to our members. Now, the question is, would you want mandatory? I'm not sure everyone out there would say yes, they want mandatory training. It's made available. Granted, it should be. When Doug was saying early on, when the act first went through and we did the 28 sessions around the state, we had a couple thousand people that showed up, and that was news media, county commissioners, and township supervisors. So I think even if it isn't mandatory, go through the mandatory, I think what the Office of Open Records is doing and should continue to do is make it available and work towards getting more compliance with the act.
Gentlemen, thank you very much.
Thank you.
And at this time, we would like to bring forward Erik Arneson, the Executive Director of the Office of Open Records, to discuss some key rulings and also some foreseen improvements to the state open records. Erik, welcome.
Thank you all for being here this afternoon. As everybody else has said, thank you so much to Neumann University for putting this on. It's a terrific day, I think, and wonderful to hear so many perspectives on the right to know law. Please, if you have questions for me, I'd love to do that. If you had questions for earlier panels that didn't get answered, feel free to resubmit them. I'll answer just about any kind of question there is, which always makes my staff nervous when I get up in settings like this. But I will talk about a few important court cases and some of the potential amendments to the law. Some of that has already been discussed earlier today. First, I'd like to talk just a little bit, go under the hood even a little bit further about how this came to be in the first place. Everything Senator Pileggi and Governor Rendell said before is correct. What wasn't said was when Senator Pileggi became the majority leader in November 2006, he collected staff from a couple of different offices, his existing staff, some leaders' staff from the previous majority leader, which is where I came from, brought in Dave Woods from the private sector, who had some Senate experience before as well. And he sat us down and he said, look, the public hates us. Let's be honest. The public is not pleased with the General Assembly right now. And one of my primary goals is going to be to reverse that public view of the General Assembly. How do we do it? And we had a number of ideas. One of the suggestions that I made was to reform the open records law, to make improvements to it, also known as the right to know law. They're synonyms. And Senator Pileggi, pardon me, Senator Pileggi, I know, thought about it long and hard because he thinks about everything long and hard before he makes a decision. But my memory here really is that it was a very quick, yes, let's do that. He drew on his experience as mayor in the city of Chester. He had had a good deal of experience there dealing with records requests under the previous act, dealing with both citizens and the media, making those requests. And 2 months after that initial discussion in his office, he stood in front of the Pennsylvania Press Club. My recollection is that John Baer was hosting that event that day, and he announced his plan. And 2 months after he was in front of the press club, the bill was introduced, and less than a year after that, it was enacted into law, signed by Governor Rendell. Rewriting the open records law, I really believe it's no exaggeration to say that it was bold and visionary. It really did transform Pennsylvania in any measure of transparency. And hiccups aside, I think it has been an unquestionably good thing by any objective measure. Even introducing it required a level of leadership that is all too rare in politics, and being able to get it through the entire process in the first session it was introduced, a massive bill like that. Anybody familiar with the general timetable of legislation through the Pennsylvania General Assembly, or I would suggest any General Assembly in any state in this nation, or Congress, knows that it is never a quick process. It took a lot of work, a lot of determination, a lot of discussions, a lot of negotiations, but all through the entire process, Senator Pileggi was there just nudging people along. Hey, we need you to do this. Come here. Let's talk about that problem. We can work this out. And eventually we did get it across the finish line. If we are to have government that is truly of the people, by the people, and for the people need to know what their government is doing, and that's what the open records law enables. And so I thank you all for being here today and showing your interest in this topic. And I know some of you represent the media, some of you represent agencies, some of you are just interested in the process, and it's a really important law, I believe, and I'm glad to have everybody here and to talk about it. A few statistics that have been discussed today I think are worth repeating. The Legislative Budget and Finance Committee, that was the first time anybody had endeavored to try and figure out how many requests are made every year. The Office of Open Records, we have always known how many appeals get filed every year. They come in our front door, so we can count them one by one, and it's roughly 2,500 appeals each year is about where it's leveled out. But the LBFC study found for the first time 109,000 requests filed in calendar year 2016. Fewer than 3% of those were appealed to the Office of Open Records. Some appeals go to other places, but the vast majority come to the Office of Open Records. And what that means, of course, is that 97% of right-to-know cases end at the request stage. And I take two lessons from that. First, it is extremely important for agencies to have good agency open records officers, because having a good person in that position who not only understands the law, but also has good skills in dealing with requesters who are not always reasonable, but can often be talked to and negotiated with even at that level. Having a good person there can really save an agency a lot of headaches and even a lot of money if things eventually go to court. Second, it shows me that the open records law is by and large working. And that in and of itself is noteworthy. Very few laws get passed, right, that affect every state agency and every local agency in the Commonwealth. Most laws are targeted to schools or to boroughs or to the Department of Environmental Protection or something much more specific than that. But the right-to-know law put a new responsibility on every agency across the state, and those agencies have responded overwhelmingly in very positive ways. There are always exceptions, but generally speaking, it has been a very good process that agencies have put in place to handle these requests. A few of the significant cases that we've had through the years decided either by the Office of Open Records or by the Commonwealth Court or the Supreme Court. We talked about home addresses a little bit earlier and the constitutional right to privacy. That is still developing. There are a number of situations, of course, where home addresses need to be public. Melissa Malewski talked earlier a little bit about when a statute makes it clear that something is public. And my view is that if there's a statute that clearly makes a certain set of records public, the General Assembly has done the balancing test for us, and the governor who signed that bill into law has done the balancing act for us. So there's really not much of a need for an agency or the Office of Open Records to do a balancing act in that case. It's really been done by the General Assembly. Another example that I like to use are residency requirements. There are some parts of the liquor laws, for example, where you have to reside in a certain area to be able to qualify for certain licenses. People have a right to know whether the people getting those licenses meet those qualifications or not. Much more commonly than that, state senators need to live in their Senate districts. State House members, same thing. Borough council, same thing. And so people have a right to know, do the people we elect meet the requirements of their office? And so in those cases, the home address needs to be public for somebody to be able to properly evaluate that. Third-party contractor records, again, something that we put into the law, and I think to be entirely candid, we weren't entirely sure how that was going to work. As it has developed, I think Pennsylvania is really a leader in making sure that when a third party is doing some function of government, that those records remain public. Just because the record might physically be in the possession of the contractor does not take it out of play in terms of its public nature in Pennsylvania. I see that my time is running short. I don't want to be responsible for making everybody late, so I'm going to make a few more points here, and then if there are any questions, I'll be happy to tackle a few quickly. On training, we are definitely going to be doing more training online. We'll have webinars, we'll do more YouTube videos, that sort of thing, so please take a look at our website. There's a newsletter that we do occasionally as well that you can sign up for at the website to learn about those things. In terms of the cost to agencies, I am 100% sympathetic to especially small agencies, but every agency that gets hit with commercial requests. I completely support the proposal to allow agencies to charge an hourly rate in terms of those. But in terms of the overall cost of the right to know law, it's certainly a fair thing to look at, but it's interesting. I think in part it's because it's such a new law. We don't always look at those kinds of costs with every law, right? We all expect, I live in Cornwall Borough, Lebanon County. It's got some small neighborhoods, but it also has some big areas of state forest. We all expect Cornwall Borough to plow every single mile of road, and on a per household basis, it's a lot cheaper for Cornwall Borough to plow Pine Street, where I live. My home address is 103 Pine Street. And because it's house after house after house. There's other places in Cornwall Borough where it's much more expensive on a per household basis. But none of us really expect Cornwall Borough to structure some sort of a snowplow fee where it's more expensive for some people than others. And you know, every law has a cost, and every law impacts people differently. And so it's just something to keep in mind, I think. As we go forward, I think we'll see a little bit less of that, especially once we get the commercial requester issue taken care of. And finally, I just wanted to mention on the issue of bad faith, that hasn't come up too often in the 10 years since this law was enacted, which is great. Has come up a few times. The Philadelphia District Attorney's Office was chastened by the Philadelphia Court of Common Pleas at one point. We recently found the city of Reading to be acting in bad faith because they ignored requests repeatedly and they ignored appeals repeatedly. Now, we can issue findings of bad faith from the Office of Open Records, but the real danger for agencies if it goes too far is that the courts can fine them for operating in bad faith. I hope we don't see too much of that going forward, but it's something to keep in mind. All right, I have two questions up here. One is, why is the state legislature exempt from the Act? They are not. They are treated differently under the Act. There's a list of about 20 different kinds of records that are defined as legislative records. Those are all public. So I'll change the question a little bit, and rather than why is the state legislature exempt, why are they treated differently? And I think the answer to that is that every branch of government has different responsibilities, different duties, different powers. The executive branch, for example, has the power to send somebody into this room, pick any one of us up, put us in handcuffs, and put us in jail until they finish whatever process that is. They can take away your freedom. The legislature can't do that. So the legislative process has a very different role in our government than what the executive branch does or what the judiciary does. And so, so much of what the legislature does is internal, pre-decisional, and deliberative, which is one of the exceptions in the law, that it would, to a large extent, be covered by that. Another thing to think about, too, is you write letters to your state legislators. I hope you do, and you share your views on different bills that are pending and different issues. I don't know about you. I'm not that keen on having my particular personal views on bills pending before the General Assembly being a record that people could request. So I think that the fundamental nature of what the legislative branch does is different enough that it warrants different treatment. I think it's a completely fair debate to have. Did we treat them too differently? Should more of the legislative records be public or not? That's a very fair question, a good debate to have. But as to why they're treated differently, that's the answer there. Okay, another question. Resident A complains to the township that neighbor B is violating a local code. The township issues a citation against B. Rather than A and B, I'm going to just say Erik Arneson complained to the township that Dave Woods is violating some local code. The township issues a citation against Dave Woods, and Dave disputes it. Can Dave use the open records law to find out which neighbor complained to the township? Well, I kind of just outed myself, but no is the answer to that. Under the law and under case law, complaints submitted to an agency, particularly if they result in an investigation, and in this case it resulted in a citation against the hypothetical Dave Woods, then those are not public under the right to know law. So it is not something the agency has to release. Now again, the right to know law is not a confidentiality statute. The right to know law itself does not prohibit the release of anything. It allows agencies to withhold things. So if an agency chose to release that information, they would not necessarily be violating any law. They certainly would not be violating the right to know law because, as Senator Pileggi said, they always have the discretion to release more. But what we see is on a routine basis, that kind of information is withheld. We have said it can be withheld. The courts have said it can be withheld. And that's what typically happens. All right. Thank you all so much. I really appreciate you being here.